크리에이터이신가요? 그렇다면 artlist.io에서 무제한으로 고퀄리티 오리지널 음원을 사용해보세요. 비쌀 것 같다고요? 새로운 월 9.99달러 플랜을 이용해보세요. 안녕하세요, 비디아트.
Hi, I'm Craig, and this is Crash Course Government and Politics. And today we're going to try to define one of the trickiest terms in government and in the Constitution, and that is certiorari. No, we've already defined that. Due process of law. On the most basic level, due process is what it means to have a fair trial. But as we'll see, it's a lot more than what goes on in the courtroom. Due process can refer to any type of legal action, but we're mostly concerned with criminal procedure here, mainly because it's always the government that brings criminal charges. Last time, we looked at search warrants and probable cause, and it's fair to say that this is the beginning of due process. But search and seizure is the Fourth Amendment. In this episode, we're more concerned with Amendments 5 and 6. And most important, we'll be explaining some of the aspects of the legal system that you've probably heard if you've ever watched a cop show. Before we move forward, let's look at the 14th Amendment. You'll remember from episode 23 that the civil liberties enshrined in the Bill of Rights initially applied only to the federal government. State governments could violate them until the cows came home, which in 1789 is how they measured time. This changed with the 14th Amendment, which allowed the court to incorporate the rights against the states over time. This is especially important with criminal procedural rights and liberties, because most of the time, criminal cases are brought by state governments. So the part of the 14th Amendment that applies here is, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. You can see that it refers directly to states, and that it says they can't deprive a person of life, kill them, liberty, lock them up, or property, fine them and take away their stuff without due process of law. But what does it mean? Serious fans of jurisprudence, and you know who you are, know that there are two concepts of due process floating around out there. The first is substantive due process, which is a blanket prohibition on government infringing on fundamental liberties. If you think that this is kind of vague, you're not alone. The court...
Hi, everyone. Okay, so now that my access to the Zoom has become more streamlined, it seems like I have a little more time to start the class. I like to show these video clips as a pointing out extra source of information you can go to if you want a crash course on U.S. government politics, for example. So you can see episode 28, these have been quite developed. All right, so before I forget, let's go ahead and go to the cyber campus and do the attendance. And so make sure you can see this. So we go to attendance here and go to week 9. We're still in week 9 officially because of the start on Wednesday, at the beginning of March. And your number is 252. Someone put down the microphone. Skipping through along here, the third branch of the U.S. federal system, the judicial branch. And let me do what I did in a previous class and highlight the coverage of the judiciary in the book that is not a book specifically on American government and politics. This is a textbook, a very popular textbook in the United States, a very good textbook, I think, by James Danziger called Introduction to Political Science. And so it's not about America, although of course it has lots of American examples because we're teaching to an American audience typically using this book. But it's supposed to be an introduction to political science and the study of political systems around the world. So to put the U.S. judicial system in broader comparative context, political science comparison is what it's all about. This is the coverage of the judiciary. And this author, James Danziger, highlights that ambiguities usually exist regarding the rules because the rules in each society are under the deep influence of human culture, history, and politics. So what exactly does the rule mean that exists either in the Constitution or in a law? How has a rule been violated? Who are the guilty actors in violating the rule? How serious is the offense? What sanctions or punishments are appropriate? The adjudication function in every political system resolves these kinds of ambiguities. So yes, that's an important point to make right now, that the judicial branch is a political branch of government. Although, of course, if people tend to believe that the legal system and the court system is non-political, then that is an indicator that that political system is habitually accepted by the individuals within the society to believe that the laws and those who make the laws are acting in the right and correct way, and that the law should be obeyed. So evidence that this normative habitual acceptance of the laws prevail is evidenced by the view in the United States held by your typical, not all, but your typical American citizen that the judicial system is not political. But of course it is political. Everything's political. Everything is political, including this class. But that's on a more abstract, fundamental level. But so the judicial branch, many political systems have established judicial structures whose primary role is, or at least appears to be, adjudication. And so aspects of adjudication, to interpret and apply the relevant rules or laws to a given situation is the purpose of adjudication function. The main objective of adjudication in Switzerland, in US, and Korea is to settle the dispute when the issue involves civil law. So civil law means concerns the rules regarding the relations between private actors, between businesses, between individuals, between private actors. Examples here include divorce, contract law, personal liability litigation, and child custody cases. Again, going back to Max Weber, mentioned in this class and during our individual conference sessions, Max Weber claimed or defined the state as that which has a monopoly on the legitimate use of force in society. Of course, if I get into a divorce and I shoot my wife, my ex-wife, that is violence, but that's not legitimate use of violence. Only the state, according to this ideal typical picture of the state described by Max Weber, only the state has the right to use violence. And the state does use violence to enforce the laws, right? The state can employ deadly force to enforce the laws. So to the extent to which people believe that the state does have that monopoly is also an indicator of the extent to which people have come to accept the rules implicit and unconsciously, implicitly in society, have come to accept them by habit. So adjudication can be an important mechanism of social control. And that's an important point. We're all controlled, even if we don't know it. Even if we're habituated to that control, we've come to accept that control, we're still controlled. And typically we become aware of that control when we don't like it. Like, for example, in the case of the United States, so much of American politics is still responding to the challenge to social control and the habituation to it that had prevailed due to the Vietnam War and the hostility of the Vietnam War and the new left social movements that began in the 1950s, including the civil rights movement, but also the feminist movement and the gay rights movement, and so on. So an adjudication can be an important mechanism of social control when an individual or group behaves in a manner which the authority representatives interprets as offensive against the social order. So, and so it goes on here, arbitration regarding the behavior of the political system itself can be the center of adjudication in some instances. So if the political system is acting in a bad way, then the courts can also play a role in finding the authorities liable, and that the authorities have to make redress for inappropriate acts that the court views as being inappropriate. So judicial structures. These are specialized structures. The judiciary are features of most, but not all political systems. The system of courts and personnel that determine whether rules of society have been transgressed. So, can you see this? Should we see this? Make sure I'm sharing the right screen here. Okay. There are specialized structures that determine whether or not the rules of society have been transgressed, and if so, whether sanctions ought to be imposed on the transgressor. So most political systems do have a hierarchical system of judicial structures, while of course there's variation among the different national judicial systems. and most judicial systems have subsystems, which are responsible for different aspects of adjudication. So that was briefly highlighted in that video clip I showed you earlier, that most criminal cases for burglary, for theft, for murder, those are tried by state courts. State courts in the United States, the state of Ohio, the state of California, they deal with the overwhelming majority of court cases because they deal with criminal law. And criminal law is something which has developed on the basis of American federalism 240 years ago. But now we see, now that we are here at the beginning of the 21st century, that the federal system will intervene to stop the state courts from violating the civil rights of individuals according to the federal court's understanding of the content of the Bill of Rights and the other amendments, including the 14th Amendment of the US Constitution. And as we said, and it's described in the O'Connor and Sabato book, you know, after the 14th Amendment was adopted at the end of the Civil War to try to guarantee everybody, black and white, the right to a fair trial, it really wasn't enforced on the states. So the southern states in particular would violate what we consider today to be the civil rights of black people because the 14th Amendment was only seen to apply to the federal courts, not to the state courts. But that's changed, particularly in the 20th century. Not too long ago. Provisions to create a so-called independent judiciary are in the constitutions of many states, especially constitutions which founders have written in the last 3 decades. So that's an important point. And say in the last 4 decades. So since the breakup of European empires and the creation of new states, this claim of the ability to create an independent judiciary is an interesting one. In every political system, the legal system and the set of judicial structures are political. Adjudication by its very nature entails crucial decisions about the allocation of values and meanings for a society. Therefore, speaking about an independent judiciary is only reasonable in assessing the extent to which the judicial structures make decisions and take actions which are at variance with the other powerful political structures in the society. In particular, this stipulation relates to executive, legislative, and administrative structures. So the judicial system is significant, really ultimately only insofar as it stands up to the executive and legislative and bureaucratic structures and their actions by their officials regarding people in the society. And to the extent to which the judicial system actually does that and restrains the bureaucracy or the presidency or the Congress, then we can talk about judicial system being a real independent branch of government. But in fact, the judicial structures in most states consistently support and rarely challenge the power and authority of the top leadership in their society. And perhaps the most high-profile case of this is Russia. You know, I've been around a little bit longer than most of you, right? So I remember when the Cold War ended and the Soviet Union ended, and there was great hope that the Russian Supreme Court is really starting to act like an independent judicial actor, carrying out judicial review regarding the Russian government and trying to safeguard the rights of the Russian citizens against abuse of bureaucrats and state agents and private actors hiring thugs and assassins to kill their enemies. But that's pretty much faded away, at least in terms of the coverage we're getting in the media over, for example, the Russian dissident Alexander Navalny or other individuals. It seems like the Russian court system rubber stamps what the Russian government wants them to do, what Vladimir Putin and his authorities, they want Alexander Navalny put in jail, he'll be put in jail. And of course, China and the communist systems, they also expect that their judges follow the dictates of the party in their rulings. Okay, so go on here. However, no systematic research exists to clarify this question, which is interesting. Indeed, in general, the judicial structures are dependent on political power for their own power and survival. But keep in mind, right, that these courts, they can rule that the behavior of the executive branch, of the administrative bureaucracy, of the Congress is unconstitutional or illegal. But they still require elements of the government, other branches of government, to implement the court's ruling. I mean, the judge himself is not, or herself is not going to enforce it. They're not going to arrest somebody, right? So it requires that the other elements within the society view the judicial system as legitimate and authoritative, and its rulings have to be enforced. And that began to come under some challenge, in particular during the Trump administration. Of course, Donald Trump was only in office for 4 years, so the resistance to implementing the court's rulings became problematic because the enforcement of the judicial system occurs through the executive branch, the Department of Justice, led by the Attorney General. The Attorney General is a cabinet secretary that serves the president. So if the court rules that the Trump administration is acting in an inappropriate way, in some way, or the bureaucracy of the government during the Trump administration is acting in an appropriate way on very many different policy area issues, you still rely upon the Department of Justice under the Attorney General to enforce that ruling. And so there has been talk about maybe there needs to be some kind of reform of the Department of Justice system, but like everything else in the US government, it's extremely difficult to carry out far-reaching changes in the political system. Of course, it may come back to affect us if Donald Trump runs for re-election beginning next year, and if he wins. However, the judiciary is relatively independent in some political systems. By exercising the power of judicial review, such judicial structures can reinterpret or even revoke the policy decisions of other political structures. And having a very strong system of judicial review are about 1 in 10 states in the world. So about 200 states, so 20 states have a strong tradition of judicial review. And Danziger includes Canada, Colombia. Again, Colombia is a very violent place with a long history of civil war. So even if there's judicial review, doesn't necessarily mean that there's social peace. And he includes Germany, India, Israel, Italy, I don't know, Israel, yeah, even so, yeah, I mean, even though there's strong tradition of judicial review does not necessarily mean that it's a society that has equal rights for all of its inhabitants on its territory, like the occupied territories of the Palestinians. Not Italy, Mexico, Norway, Switzerland. So Switzerland's in there, and the United States. I think you probably also put pre-apartheid South Africa, that you had judicial review in the white-dominated state of South Africa before 1994, but again, most of the population was not enfranchised, treated as equal citizens. They were not even considered South African citizens. But that's another story. To enforce this decision, the judiciary is dependent upon other political structures, especially executive and the administration. The judiciary might still respond to the political pressure even when it does strive to maintain some political independence. So that's a big question, right? Since this is a course on US government politics, perhaps one of the most high-profile cases was during the Great Depression. You know from this class that the US government expanded greatly to deal with the challenges of the Great Depression. So Franklin Delano Roosevelt, FDR, was president, and under his administration, literally hundreds of new agencies, federal government agencies, were created to regulate the behavior of the economy and the actors within it, including workers trying to form unions, not to mention regulating different aspects of trade and commerce and business. And of course, Franklin Delano Roosevelt was dealing with the greatest crisis confronting the United States domestically since the Civil War. And of course, the world itself was moving into fascism at this time. And his New Deal, that was the name for the overarching name for his programmatic plan to deal with and address and overcome the challenges of the Great Depression and the misery and suffering that it was causing so many Americans, was challenged in the U.S. Supreme Court. And U.S. Supreme Court in the 1930s was dominated by individuals who were appointed by Republican presidents over the years, and they struck down many of Franklin Delano Roosevelt's initiatives, which, from his point of view and his supporters, it was equivalent to wartime crisis situation confronting the United States, while, of course, this economic misery around the whole planet during the worldwide Great Depression was contributing to the rise of people like Hitler in Germany. And so Franklin Delano Roosevelt proposed to expand the Supreme Court, add new justices to the U.S. Supreme Court to overcome the majority of the members of the Supreme Court that appeared to be opposed to his New Deal policies. And he failed in that. But it did certainly create a political environment within the United States that appeared to pressure these justices to back off so that they stopped blocking Franklin Delano Roosevelt's policies. And that's an issue that's come up again today. Since Donald Trump, when he was president for 4 years, he was able to nominate and appoint 3 justices to the U.S. Supreme Court. On the 9 there, 3 of them were approved by him. So, of course, Donald Trump's legitimacy as being president has been challenged by some, claiming that, well, the Russians somehow intervened to help him steal the election in 2016 against Hillary Clinton, although that's never been definitively proved. And that, of course, we know he did not win as many votes as Hillary Clinton, but he still won the Electoral College. And then after he lost the election in November 2020, he instigated a violent attack on the U.S. Congress on January 6, 2021. But those 3 justices that he nominated are still there. Brett Kavanaugh, Neil Gorsuch, and Amy Coney Barrett, a female. They were approved and vetted by an interest group, the Federalist Society. And the Federalist Society is a group of very conservative legal scholars who oppose the expansion of the federal government to bring about what people on the left, on the progressive side of the political spectrum, call social justice. And so these 3 justices, plus the 3 that were already there, well, the other ones who were already there, produced a 6-3 bias with 6 justices appointed by Republicans and 3 by Democrats. The 3 Democrats are, Ketanji Brown Jackson, the first Black woman, will be sworn in this summer, I think. Yeah, this summer. But before her, Stephen Breyer, Sotomayor, Puerto Rican woman, and Kagan. And these are 3 Democrat appointed. So these 6 justices, including Trump's 3, may well, for example, rule to allow states to ban or severely restrict access to legal abortion services, to legal abortion. And the question is, will they do that? Or, of course, will the possible hostile reaction among many Americans, not just women, of course, lead to such a hostile response politically that these justices who've been nominated by Trump and approved specifically with the hope that they would vote to overturn Roe versus Wade 1973 Supreme Court case that legalized abortion, they have been chosen specifically because they would likely overturn Roe versus Wade. Will they do it? And they will know next month because they have to rule by next month, by June, end of June. And what will be the political reaction in American society? And that's been a topic of speculation. fascination in the media. I mean, again, according to some reports I've seen, 1 out of every 4 women in the United States, 1 out of every 4 women in the United States has had an abortion. 1 out of every 4. But at the same time, Donald Trump, the majority of white women voted for Donald Trump in the elections in 2016 and 2020. Not all women, white women voted for Donald Trump, even though they knew Donald Trump was going to appoint these anti-abortion access judges on the court. So let's see what they do. It's going to be very interesting. And but of course, in this discussion, brought to mind again in the media reports this dispute that Franklin Delano Roosevelt had with the Supreme Court in the 1930s. And so note that people in the top judicial decisions are likely to share the values of the ruling groups since chief executive leaders appoint them. I mean, Trump didn't hide what he was going to do if he won the election in 2016. He said he would do this, and he won. And he did it. And the dominant power group can perhaps try to ignore, replace, or eliminate judicial officials who displease them. Of course, this is a chapter from a book that covers many different countries, not just the United States. So, for example, in the 1970s, speculation exists that Argentinian junta government, the military dictatorship in Argentina, ordered the execution of more than 150 high-level judges who disappeared. And I wouldn't doubt that that is a concern for Russian judges today. That unlike the Communist Party in the People's Republic of China, where there is the institutionalized expectation that the party provides the leadership in society, the Russian Constitution, written in the 1990s under Boris Yeltsin, right, has the wording and rhetoric and ideology of liberal democracy, but judges know that assassination is a not uncommon occurrence in Russia, including, for example, of journalists who report on sensitive topics that the Russian authorities don't like, not to mention other political figures like Boris Nemtsov was assassinated. Well-known journalists have been killed, and nobody's been arrested and put on trial for that. So if you're a judge in Russia, this is a life or death issue. Note that, however, being little more than a loyal administrative arm for executive power is the most common pattern for the judiciary. That's the most common pattern across the whole world. So a truly autonomous judicial system is a blessing. In these contexts, the reality is that the judicial structures serve the political elite, despite the rituals of the judicial structures, which offer the appearance of protecting justice. And so just to conclude, the existence of a truly independent judiciary is a rarity, despite the fact that most judiciaries exercise some discretion in adjudication. Okay, so let's cover the American judiciary. And keep in mind, the judicial system has become more and more important in policymaking, along with the decline of the legislatures in this modern, highly complex and developed society and economy. The judicial system in the courts, together with the bureaucracy, has become more and more important and significant in reality at the expense of the legislative branch. So here is the PowerPoint slides that I sent out to you earlier, and I think you can see that. And just in case you can't, let me make sure I'm sharing the screen. The judiciary. So again, this was in the Constitution, was written 240 years ago. The Supreme Court is the only court that's explicitly referenced in the Constitution, the U.S. Supreme Court. The Constitution does give the Congress the power to create other courts. So the U.S. Congress can create and abolish courts. The framers devoted little time to the creation of the judiciary. They believed it posed little of the threat of tyranny that they feared from the executive and the legislative branch, right? That their focus was on the executive branch becoming too powerful and the Congress being too powerful, coming up with a balance so that the federal government could actually act and be effective without allowing different branches to become so powerful that they oppress unpopular minorities within their society. And framers left it to the Congress to design the federal judiciary. So as I mentioned, the only court that is mentioned in the US Constitution is the Supreme Court. And the Constitution does give Congress the power to create other courts. The judicial branch is covered in Article 3. Keep this in mind, right? This US Supreme Court plays such an important role in the expansion of civil rights. I already mentioned Roe versus Wade from 1973, Brown versus Board of Education, I think in 1954, that made education, segregation of races in education unconstitutional. These are acts of the US Supreme Court, not acts of Congress. Later, the Congress would, and the presidency, the executive branch would pick up the football, so to speak, take the, if you're not playing American football, if you're playing European soccer, somebody kicks the ball and kicks it to you and you take the ball and you take it forward. Yeah, that has happened. But the Supreme Court has played a critical role in encouraging certain trends through its actions to create what we consider obvious today, that you should not openly separate black and white students in schools. That seems obvious today, but it wasn't obvious 80 years ago in the US. And as I mentioned, even court decisions that are almost 50 years old from 1973, we might say, well, it's obvious that abortion access should be legal, at least under various circumstances in the United States. That might change next month. A number of states, Ohio, I think, maybe not, Oklahoma, Texas, they're already passing laws because they're dominated by Republican Party members in the legislature and in the governor's mansion that are passing laws right now that are preparing for the US Supreme Court to overturn Roe versus Wade to make abortion illegal, for example, in Oklahoma or Mississippi. So the courts are really, really important. I mean, it was a US federal Supreme Court decision that made laws in many states that barred white and black people from marrying each other illegal. Loving versus Virginia, 1967. US Supreme Court ruled that such laws that forbid the mixing of races through marriage is unconstitutional. I was 5 years old when that happened. It wasn't that long ago. Or many other decisions as well. Most recent one, Obergefell versus Hedges. I think in 2015 that made gay marriage legal. It's not referenced in this slide show because it happened 9 years after the slide presentation was prepared. So Article 3 in the Constitution lays out the creation of the US Supreme Court. It does not settle the question of judicial review. Judicial review is that point was referenced earlier, that the courts can review the actions of the government and executive or legislative branch and rule them to be illegal or unconstitutional. And this is the source of all that power I've mentioned. The judicial review includes, for example, reviewing the constitutionality of abortion bans, making abortion illegal. The US Supreme Court, in the language that they use, they strike down those prohibitions as unconstitutional. Evil, it's unconstitutional. And that's the process of judicial review. It's not explicitly stated in the Constitution. Again, these rules and norms become real through practice and people's attitudinal internalization of them through their socialization from the time they're born and the time they go to school to college and become professional lawyers and judges, that we just accept that the Supreme Court can do these things, make gay marriage legal. And if you're a conservative populist Republican, this is outrageous. Because I remember in the 1990s, when Bill Clinton was moving to, when he was president, to try to make gay marriage more acceptable, there were a number of states, including my home state of Ohio, that passed laws through their own state constitutional mechanisms, whether through legislation or through state referendums, to define the marriage as only being between a man and a woman. A number of states passed such laws through referendums, including my home state of Ohio. And then in 2015, the Supreme Court says, it's all unconstitutional. And now, most people, according to public opinion surveys, think that gay marriage should be legal. But according to also public opinion surveys, most people think access to abortion should be legal in various circumstances. So judicial review allows the judiciary to review the constitutionality of acts of other branches of the government and the states and of the states, Ohio, California, and so on. Judicial review was settled with Marbury versus Madison in 1803. James Madison, who was basically the writer of the US Constitution, was president. Marbury sued Madison because Marbury was supposed to get a job in the federal government. Jefferson left office and Madison replaced him, and Madison would not hire him for his promised job that Marbury wanted. And Marbury sued Madison and took President Madison to the Supreme Court. And the US Supreme Court said that Madison's decision was constitutional. And by making that ruling, claiming that we have the right to make such a ruling and making a ruling in favor of Madison, it set the precedent that the court was a place you could go to review the actions of the government, and the court could review the action and decide whether or not it was legal or not. The following are the types of cases the Supreme Court has given the jurisdiction to hear as initially specified in the U.S. Constitution, according to Article 3. So this is laid out in the Constitution. All cases arising under constitutional laws and treaties of the United States, all cases of admiralty or maritime jurisdiction, of course, trade, commerce, state commerce through the oceans was an important part of national government. Cases in which the United States is the party, controversies between a state and citizens of another state, controversies between two or more states, controversies between citizens of different states, and so on. Controversies between citizens of the same states claiming lands under grants in different states. So again, a lot of these are issues that were particularly important at the end of the 18th century. So Section 1 gave Congress the authority to establish other courts as it saw fit. Yet this appointment to the U.S. Supreme Court, this has become one of the most important issues in U.S. presidential elections because of this power and role of the U.S. Supreme Court historically, particularly in the 20th century, in shaping the United States. So any explanation as to how Donald Trump won the election in 2016 has to be his appeal to Christian evangelical conservatives. That he said, if you appoint me, I will appoint the right judges. I will promise you, I will appoint these judges that have been approved by the Federalist Society. Here's the list of judges I'll look at. See, trust me, I will appoint judges that will try to overturn Roe's Wade. So on. Section 2 specifies the judicial power of the Supreme Court and discusses the court's original and appellate jurisdiction. And Section 3 defines treason. And so again, it's not so significant here. U.S. federal court judges are appointed for life. with good behavior. They can be removed through impeachment if they do something bad, criminal. In other words, by appointing judges for life, they're not supposed to be subject to the whims of politics. So is that going to shape Amy Coney Barrett, the Catholic former professor from Notre Dame University, who Donald Trump appointed, a female Catholic conservative? She's there on there forever. She's known to be intensely against abortion. Now she's a Supreme Court justice. She can't be removed. Is she going to change her mind? I don't know. I kind of trust the Federalist Society. They know what they're doing. And so we'll find out in a few weeks here. Hamilton, one of the framers, argued in Federalist Paper number 78 that the independence of the judges was needed to guard the Constitution and the rights of individuals. Some checks on the judiciary included Congress has the authority to alter the court's jurisdiction. So Congress can decide through law what kind of court cases the courts can consider and what they cannot consider. Congress can propose constitutional amendments that, if ratified, can effectively reverse judicial decisions. Congress can impeach and remove. What happened there? Sorry. Congress can impeach and remove federal judges, which they have done because federal judges are human beings and some of them are criminals. They do criminal things. And presidents appoint federal judges with advice and consent of the Senate. So the president has to appoint, and then the Senate has to approve. And of course, this is part of this intense political polarization over the judicial branch and the appointment of the right kind of judges to interpret the Constitution. So you'll read later in the second part of the class, when we use the other textbook, about how Joe Biden became president of the United States and the critical role of African American voters in mobilizing to support Joe Biden and saving Joe Biden's candidacy 2 years ago in early 2020. And Joe Biden has to provide his promises. He has to satisfy his promises that help mobilize African American voters who remember that Joe Biden was Barack Obama's vice president. Barack Obama is so popular among particularly, not only, but particularly African Americans. So Joe Biden promised that if he won the election, he would appoint the first Black woman, African American woman, to the U.S. Supreme Court, and he did. And she was approved just 2 weeks ago. That's Ketanji Brown Jackson. She will be sworn in the summer. So he's going to satisfy these Black voters and save his candidacy for him. And so the Judiciary Act of 1789 and the creation of the federal judicial system, it established the basic three-tiered structure of a U.S. federal court system. At the district courts, at least one in each state, each staffed by a federal judge. A circuit court, this is an avenue for appeal. So again, the idea, of course, back then at the end of the 18th century, judges, particularly the appeal court judges, they would ride on a horse and they would go on a circuit, hearing appeals. And those appeals were supposed to make sure that the federal court rulings followed proper procedure. That was it. So they weren't permanent appointees, right? Each circuit court initially composed of one district court judge and two itinerant Supreme Court justices who met as a circuit court twice a year. And so that's where the term circuit court comes from, that they were not considered permanent courts in place, only there to consider appeals. The Supreme Court set size act. The size of the Supreme Court was set in an act of Congress. So originally it was the Chief Justice and 5 associates. In 1869, the Congress passed a law that said the number of Supreme Court justices is set to 9, because this is an act of Congress. So Franklin Delano Roosevelt threatened to try to increase it, and then there was talk about Joe Biden threatening to increase it, proposing to increase it, but it hasn't happened, and it probably won't happen. Okay, so you can see this. The U.S. Supreme Court hears 89 cases in return, including this court case now being heard next month involving the state of Mississippi. That will the Supreme Court hears 80 to 90 cases per term, and almost all the court cases that it hears are cases on appeal from U.S. courts of appeal. So this case that's coming up regarding Mississippi versus Jackson. What is it? I should have made this English, sorry. I'll have to find it later, but it's the state of Mississippi has passed a law that basically makes abortion much more restricted against reproductive services, and I can't really find it right now, but this court case came up through the appeal system, and I guess maybe I can just show you that this is a big focus in the United States, and yeah, so you can see there's a Wikipedia entry for each of these states, and these, of course, southern states and conservative states are moving to ban abortion. It probably will never be a ban here in New York and California. So if you're a wealthy person with money and time, you need an abortion, you can travel from Texas to New York State. But if you don't have the money, you don't have the time, and you have to work, and you have to go to work, you can't just take 2 weeks off to go get an abortion, you're in trouble. But again, the United States is not really supportive of poor people. State initiatives. So let's just go back to these cases. So most of the cases of the U.S. Supreme Court, they come on appeal through the federal court system, then through the appellate court system, and then they'd have to decide whether or not the Supreme Court has to decide whether or not it wants to hear the appeal. And of course, the Supreme Court receives thousands of appeals over the course of its term in each year, but it only agrees to hear 80 to 90 cases. In most cases, it lets the appeals court decision stand. A few cases focus on original jurisdiction laid out in the Constitution, but most are appellate court decisions. The U.S. Court of Appeals, there's 13 courts handling about 50,000 cases per year. They hear appeals from lower federal courts, regulatory commissions, and so on. And then there are the U.S. district courts, which 94 courts, 325,000 cases. Compare that with the state courts. These are key courses that include criminal cases. So state trial courts here, 100 million filings per year. Mississippi, Ohio, California. And then the appellate courts within the states, they handle approximately 300,000 cases per year from all of these cases that are heard. And the 50 Supreme Courts, each of the states has a Supreme Court that handles about 100,000 cases per year total. And these courts, typically the judges that hear these cases, they're elected. So we hold an election for the Supreme Court justices in Ohio. Is that a good or bad thing? Keep in mind, these state courts, they have the authority to put people to death, to assign execution for heinous crimes like murder. And these judges are elected. And that can be problematic, right, in terms of guaranteeing people's civil rights, including those accused of terrible crimes. And that's when the Supreme Court or the federal court can intervene. Like, for example, if there's blatant evidence that a court case in some state is assigning somebody to be executed for a crime, and the court case looks as if it was not following proper procedure, then the federal courts can become involved. But that is a 20th century phenomenon. So the Supreme Court was not considered a high-profile, high-controversy topic today. When the first session of the Supreme Court initially had to be adjourned, when a quorum of the justices that had to attend, the minimum number, failed to show up. Later, the Supreme Court decided only one major case. It was a relatively low status. One associate judge on the first Supreme Court left to become a chief justice of the state Supreme Court. So that was typically the case in the early 19th century. The federal government, including the federal court system, was not considered to be a high status job. If you were an ambitious politician, you typically, at the beginning of the 19th century, you pursued your career at the state level. But the first court did try to assert itself. It was not really co-equal with the other branches of government, but it did try to play a more prominent role. And it refused to act in certain ways when it was requested to do so. President Washington was the first president of the United States, and he asked this new institution, Supreme Court, for its opinion on the legality of some of his actions. And the court officials decided, well, we don't think that's really our appropriate role. That's interesting. The first Supreme Court justice, well, maybe the first extended term Supreme Court Chief Justice was John Marshall. And John Marshall played an incredibly important role in making the Supreme Court the institution that it became. He served on it all of his professional life. And the Marshall Court played a really important role in making the Supreme Court an effective institution. Of course, he's under attack today because, like many of the founders of the United States, he owned slaves. So, for example, Cleveland State University, close to my home in Ohio, in the city of Cleveland, is a public university organized by the state of Ohio. Cleveland State has a law school, and it's the Marshall Law School. And there's a push to change its name because it's named after John Marshall, and he owned slaves. The Supreme Court tried to advance principles of nationalism and to maintain the national government's supremacy over the states. And it began to pave the way for the announcement of the doctrine of judicial review. Now keep that in mind, right? According to English Anglo-Saxon tradition, what does being truly free from oppression mean? And being free from tyranny and oppression means having the right to a fair trial. That's essentially important in common law, Anglo-Saxon, English tradition, going all the way back to the mists of time. You know, the founders of the first beginnings of the English written constitution, well, first written document laying out the principles of the English de facto constitution was the Magna Carta, the Great Charter in Latin. And it explicitly highlights in 1215 the right to fair trial. So this notion of a fair trial and guaranteeing Americans a fair trial wherever they are has been a critical focus of the expansion of the federal government's powers, as represented by the 14th Amendment, for example. That was the judgment made under Obergefell versus Hedges to make gay marriage legal, that you cannot forbid certain people from having access to marriage unless you have a really good justification for it. And just to say we don't think two men should be able to marry each other or two women should be able to marry, that's not good enough. And under the 14th Amendment, that was the justification that the Supreme Court used 7 years ago to make gay marriage legal. So this notion of equal protection under the law and a fair trial is, for Anglo-Saxon tradition, really important, and the route by which the Supreme Court has built up its authority and legitimacy. Yeah, so I already mentioned Marbury versus Madison. The Supreme Court first asserted the power of judicial review in finding that the congressional statute extending the court's original jurisdiction was unconstitutional. So that's an interesting point, that that the court ruled that the congressional law passed that gave the power to the Supreme Court to review this kind of case was unconstitutional. So the Supreme Court could not rule in favor of Marbury. And Madison liked that. He didn't like Jefferson. And so by appearing to renounce the power of the Supreme Court, he actually strengthened the power of the Supreme Court by establishing the precedent that the Supreme Court can rule on the constitutionality of congressional action. And John Marshall claimed the sweeping authority for the court by asserting that the right of judicial review was a power that could be implied from the Constitution's supremacy clause. But the immediate effect of his ruling was to deny power to the court, but the long-term effect was to establish the power of judicial review. So keep in mind, for decades and generations later, this principle of judicial review, illustrated by the US Supreme Court, would be incorporated in other new constitutions of other new states, including, like, for example, in Germany after World War II. This notion of judicial review really got a big boost, not just in the US, but around the whole world, as a consequence of this American experience. So the American legal system has trial courts, courts of original jurisdiction where a case begins. Then there are appellate courts, courts that generally review only findings of law made by lower courts. In other words, was the proper procedure followed, the proper law applied? And jurisdiction, that's authority vested in a particular court to hear and decide the issues in any particular case. Original jurisdiction, the jurisdiction of courts that hears a case first, usually in a trial. Courts determine the facts of the case under the original jurisdiction. And the appellate jurisdiction, the power vested in an appellate court to review and to revise the decision of a lower court. So the Supreme Court is supposed to get involved if there's disagreements among the appellate courts. So typically, there's these different federal courts, 96 federal courts in the United States. They make rulings on similar cases. Those rulings are appealed by the loser, typically, almost always, in that case, to the appellate court above them. And there's a disagreement in the appellate courts as to how to deal with that particular case or that particular issue. Then the Supreme Court's supposed to get involved, typically, to resolve disputes among the appellate courts. And that Supreme Court is supposed to then establish the precedent that the other future court decisions are supposed to follow. So that's why it's a big deal. After almost 50 years of Roe versus Wade, and all of the precedent, and all the court cases established since 1973, that the US Supreme Court might decide that, well, we're now going to change our ruling, and 49 years of precedent is, well, you know, it can be changed, just like it was the US Supreme Court in Plessy versus Ferguson in, I think, in 1896, the late 1890s, ruled segregation's okay. And then in 1954, early 1950s, it changed its mind in Brown versus Board of Education. So it'll change its mind again in Roe versus Wade. That's a problem for Anglo-Saxon, not continental European, but Anglo-Saxon common law precedential tradition. Precedent is supposed to be really important. The Latin term is stare decisis. Let the precedent stand. Continental European law, under the influence of Roman law and Napoleonic law, code law is different. That the law of the state as adopted by the Republic is the law, and it can change however it needs to change. But in Anglo-Saxon law, common law tradition, precedent is supposed to be dominant. But it's fading away. They're converging, these systems of laws. There's the common law, Anglo-Saxon tradition, and the code law, the Napoleonic law, the Roman law tradition. So I assume Switzerland is in the code law tradition. The American legal system, codes of behavior related to the protection of property and individual safety are constitute criminal law and civil law. Remember, the kind of people taking this courts in the United States, these are typically students that have plans to go to law school and become lawyers, attorneys. So this is an important, particularly important chapter for them, because they're thinking about, at least, maybe I want to become an attorney and work in the legal system. Criminal law versus civil law. Codes of behavior related to businesses and contractual relationships between groups and individuals. So contractual relationships between groups and individuals is the focus there. Okay, the federal court system, there is constitutional courts. These are federal courts specifically created by the US Constitution or Congress pursuant to its authority in Article 3 of the Constitution, and legislative courts. These are courts established by Congress for specialized purposes, such as the Court of Military Appeals. District courts. We already mentioned there are 94 federal district courts, staffed by 646 active judges, assisted by more than 300 retired judges. No district courts cross state lines. Each state has at least one federal district court. The most populous states have 4 district courts: California, Texas, and New York. Let's see, let's do an exercise. So, judicial branch in a flash. So, here is your reading case, and I don't know if I'm going to actually have time. Let me send you this file. So please open this file that I'm sending you. And let's go through this file before we go to some exercises in the file. So this has been updated. It's all about the robes. Well, it goes on and says, actually, it's not. The cool black robes judges wear are the first things a lot of people think of when they hear the word judicial. But the first thing you really need to know is how courts were created. The only court the United States Constitution actually creates is the Supreme Court, the highest court in the country. The Constitution also allows Congress to create other courts. When Congress created those courts, the federal court system was born. So two court systems. Here's the confusing part. It says there are two systems of courts in the United States. The federal court system deals with disputes about laws that apply to the entire United States. State court systems mostly deal with disputes about state law. Each state has its own court system created by its own state constitution. Whether people take their case to a federal or state court depends on the laws involved in the case. The good news is that the state court systems usually work just like the federal court system. Which court to use? Each court system deals with certain kinds of cases. Federal courts hear cases involving federal laws, the U.S. Constitution, or disputes between citizens of different states. State courts hear cases involving state laws or the state's constitution. They also deal with disagreements between citizens of the state. State courts normally resolve the kinds of issues you hear about in everyday life, such as family members, like divorce, accidents, crimes, and traffic violations. Most trials you see on TV involve a person who has been accused of a crime, but criminal cases are not the only kind of cases that go to trial. Sometimes people have a disagreement that they can't resolve on their own. Often, one side feels that the other side violated their rights in some way. This kind of case is called a civil case. The goal of a civil case is not to find out whether someone is innocent or guilty, but decide which side's version of the story is correct. So that's important to know because often private actors are sued for violations or damages in cases, for example, involving today suing big tech companies because they're violating my right to privacy, for example. They're not found guilty for criminal violation. They're typically found for violating my rights as a citizen in terms of violation of certain contractual obligations. The trial court is the first court to hear a case. Both the state and the federal systems have trial courts. In the federal system, the trial court is called a district court. In the trial court, lawyers use evidence to try to prove that their client's side of the story is what really happened. Evidence can be almost anything: witnesses, videos, or photographs, a letter, a piece of fabric, or even a murder weapon. In a jury trial, a group of 12 people listen to the evidence and decides who wins the case. The decision is called the verdict. In a bench trial, there is no jury, so the judge gives the verdict. Do you have jury trials in Switzerland? You do? You have jury trials? Like 12 people come together and they decide whether or not. Yeah. It's not over until it's over. Losing in the initial trial court doesn't mean the case is over. If the losing side thinks there's been an error, they can ask a higher court to review the verdict and replace it with a different decision. The courts above the trial court are called appellate courts. The federal system and most state systems have two appellate level courts, a court of appeals and a Supreme Court. Your state might have a different name for these courts. Asking an appellate court to review a case is called making an appeal. And so it says here, a trial court hears cases for the first time, reviews evidence to decide who is right. Court of Appeals reviews the trial court decision for error. Decisions must be followed by trial courts. And the Supreme Court reviews the appeals court decision for error. Decisions must be followed by all lower courts afterwards. So want to sound like a legal, then you can say that case is brought up on appeal, an appeal. Cases are thought of as going up through the court system. A trial court decision is brought up to the appeals court. An appeals court decision is brought up to the highest court. Once a case has been heard by the highest court, there is nowhere left to go. Appellate courts review lower court decisions to see if a mistake was made. When an appellate court makes a decision, all lower courts must follow that decision in the future when the same issue comes up again. So courts have been ruling, well, according to Roe versus Wade, the state of Mississippi or the state of Texas, they can't pass laws to make abortion illegal. But, and so these federal courts have been striking down these laws that have been passed over the years since Roe versus Wade, particularly in the 1980s and 1990s. And then the loser appeals, and they keep appealing because now they think this time with Trump's appointments of Supreme Court justices, this time the appeals will be heard and the Supreme Court will overturn Roe versus Wade. That's what they're hoping. Judges and more judges. While a trial court has one judge, most Court of Appeals cases are heard by 3 judges. When more than one judge listens to a case, the group of judges is called a panel. Usually the judges decide the case by majority vote. At the appellate level, there's never a jury. That's because a jury's job is to look at evidence and decide what happened. In an appellate court, the judges are deciding whether legal errors have been made. For the losing side in the Court of Appeals, there is one more chance, the Supreme Court, which is the highest court. And the last court is the Supreme Court. And so you can see the Supreme Court, a level of 9 judges hears the cases. State Supreme Courts often have fewer justices. The Supreme Court gets to choose which cases to take. It doesn't take very many. Often cases that make it to the Supreme Court are disputes about whether a law goes against the Constitution. Once the Supreme Court has said something is unconstitutional, that's it. Only the court itself can reverse that decision. This power of deciding what is constitutional is called judicial review. The Supreme Court has this power over federal laws. State Supreme Courts have this power over state laws. So, here's other members of the Supreme Court. And then he was appointed by Trump. First said he was appointed by Trump. Then Barrett, she was appointed by Trump. Clarence Thomas was appointed in the early 1990s. Samuel Alito was appointed by George W. Bush. John Roberts was appointed by George W. Bush. Stephen Breyer, I think, was appointed by Clinton. He was son of the second war. All these judges are Catholic or Jewish. So even though America was founded by white Anglo-Saxon Protestants, maybe until this person, he might be Protestant, but he was just put on the court a couple of years ago. So this is further evidence of the assimilation of the Catholic minorities into the American core group. He is the second Black person to serve on the Supreme Court, Clarence Thomas. He replaced Judge Thurgood Marshall, who argued the Brown versus Board of Education case and won to end desegregation. He died in the early 1990s, and George H.W. Bush nominated him to replace Thurgood Marshall. And he is a very conservative, right-wing Trumpist supporter, very conservative Republican, unlike Thurgood Marshall. So he is stepping down, and Ketanji Brown Jackson is replacing him. He's resigned. He's going to finish it next month. So I don't think we have time for bingo, judicial bingo. But what we do have time is for this exercise. So how many people in class? We have 7 people. So let's divide up into 4 groups. Well, I think the 7 includes me. So let's do the first group of exercises here. So group 1 will do A, group 2 will do B, group 3 will do C exercise. And so let me assign you to 3 different groups. And, groups. And the person at the bottom of the group listing will be the one who speaks for the group. And it is Cho Ji will speak for group 1, exercise A. And Kim Byung-gu will do exercise B. And this is exercise C. So open up those groups. So please join the groups. Please join the groups. Micah and Chojin, exercise A. Chung Do-jin and Kim Byung-gu, exercise B. And Anis and Juliet, exercise C. And so once again, the exercises here, A, B, and C. So you have a few minutes to talk to each other and come up with the answers to these. And the group that gets the most correct or the least incorrect will get an extra credit point. So, of course, if there's a tie, you both get an extra credit point. Or all 3 of you get an extra credit point. But the group that gets the most correct gets an extra credit point. So again, start please. So Anais, which group are you in? Okay, so who's your group member? Juliet? So can you communicate with Juliet to help Juliet answer the questions for exercise C? Hello, Juliet. Are you ready? Juliet? Oh, so I have to close out the rooms? So you can see Anais, are you in the room? Are you in the room, Anais? Because you're not in the room. So help Juliet. Chung Do-jin, help Kim Byung-gu. Micah, help Cho Jin. Juliet, are you ready? Oh, that's right. You're in a group, so you can't hear me, can you? 10 seconds. Okay, so who will speak first? So let me flip a coin. Heads. Okay, so Chojin.
Yes, Professor.
The only court the Constitution creates is
Mm, agree to hear cases involving appeal.
it's the Supreme Court. Okay, the Supreme Court. The only court the Constitution creates is the U.S. Supreme Court. Number two, the two court systems in the United States are. What is your answer, Chojin? Chojin?
Mm, state intermediate,
State and what?
state intermediate courts.
The state and federal court systems. State and federal. State and federal. The two kinds of legal cases are, and you can help him. Who else is in the group?
Me, I was also in the group.
Micah, you can help. So the
It was the two cases, legal cases.
two legal cases are, yes, Chojin, Micah, what are they?
Criminal and civil.
Ding, 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 ding. The job of the Court of Appeals is Micah, Chojin.
It reviews the court decisions for errors.
Correct. Good. 5. Chojin. It's difficult to take a case to the Supreme Court because Chojin.
I can take over that question because you first have to start at the lowest level, and once this has been and then you take it up to the Supreme Court. So you can't just go directly to the Supreme Court and challenge a case, but you have to first start at the lowest possible level, take it to the next higher instance and the next higher instance, and then eventually you land at the Supreme Court.
Okay, I'll give you that. 5. If you lose a case in trial court, you can Chojin. Chojin. What can you do according to the file that I sent you, or the file, this information here? What can you do, Chojin? Micah? Micah, Chojin, what can you do? No answer?
I think you can challenge the decision.
Appeal.
Or you can
Appeal.
appeal, yes.
If an appellate court affirms a case, it means what does it mean?
That your appeal has gone through, so you appeal for something and they confirm it, so I guess you can have a new trial, I guess.
Okay, all right. And 8, if a law is unconstitutional, the Supreme Court can anyone? Micah, Chojin?
I don't know the answer to that one.
U.S. Court of Appeal.
Okay. Reviews the case. Can review it. And evidence is used for what?
Sorry, which question are we on? My internet connection is not stable.
Evidence number 9. Evidence is used for
Okay. To decide a case either on your in your favor or against you.
appellate courts can affirm the trial court's decision, letting it stand, reverse the decision, or remand the case back to the trial court to start over. Okay. And a trial with no jury is called a, and these are kind of rare. What are they called?
Bench trial?
Yes, a bench trial. All right. Okay, room B. Kim Byung-koo. Kim Byung-koo.
Yeah.
So Kim Byung-koo, where do you put A? Here's civil cases. Here, here, or here?
In trial.
Okay, right. Trial. Okay. Might have a jury trial. Here or here? Or here?
I think it's in both.
No, only a trial.
Oh, trial?
Jury, yes.
Oh, yeah.
C, does not hear cases for the first time. Here, here, or here?
Appellate.
True, that's good. Okay. Here's criminal cases. Here, here, or here?
Both.
Okay. Reviews a verdict to look for mistakes. Here, here, or here?
Appellate.
Okay. And F usually has 3 judge panels. Here,
Yes.
here, or here?
Trial.
Appellate.
Oh.
Here's cases for the first time. Here, here, or here?
I think that's also in trial.
Correct. Okay. And works with laws. Here, here, or here?
Both.
Okay. All right. All right. And room C. So room C, who's room C? And let me see if I can do this right here. Room C. Room C is Juliet. Juliet. Okay, Juliet.
Yes.
Juliet. So one, 2, 3. So what is first in this sequence of events here?
I said that the first of the 3 is the first verdict is appealed.
Okay.
Then the Court of Appeals remains the case and a new
Okay.
trial begins.
Okay. All right. All right. All right. And the next one, trial is held, district court, Supreme Court agrees to hear the case, and appeal is made to the Court of Appeals. So,
Trial is held in the district court. An appeal is made to the Court of Appeals.
Okay.
And then the Supreme Court agrees to hear the case.
All right. All right. Third.
The members of the jury are chosen.
Okay.
Evidence is presented to the jury and the jury returns a verdict.
Okay. And the fourth sequence.
Congress passes a law. Supreme Court hears a case about the law and the Supreme Court strikes down the law.
Okay, that's true. Yes, yes, yes. Okay. All right. So pretty close in terms of who's winning the contest here. So now we go to, well, I think I have to shut down this computer so we have time to see the file. So let me do that.